Jurisdiction of the Supreme Court. The Supreme Court of India has the widest and most comprehensive jurisdiction among all courts in India. As the highest judicial authority, it is empowered to hear and decide a variety of cases involving constitutional questions, fundamental rights, disputes between governments, and appeals from lower courts. The jurisdiction of the Supreme Court is clearly laid down in the Constitution of India, making it the final interpreter of the Constitution and laws of the land. Through its different types of jurisdiction, such as original, writ, appellate, advisory, and review jurisdiction, the Supreme Court ensures the rule of law, protects fundamental rights, and maintains the federal balance between the Union and the states. Thus, the jurisdiction of the Supreme Court plays a crucial role in upholding constitutional supremacy, justice, and democratic governance in India. The Supreme Court of India has wide and comprehensive jurisdiction, making it the most powerful court in India. Its jurisdiction is mainly divided into the following categories. Original jurisdiction, Article 131. Under Article 131 of the Constitution, the Supreme Court of India has exclusive original jurisdiction in certain federal disputes. This means such cases can be filed directly in the Supreme Court, and no other court has the authority to decide them. This jurisdiction applies to disputes between the Union and one or more states, or between two or more states. The dispute must involve a question of law or fact on which the existence or extent of a legal right depends. Typically, these cases relate to federal relations, such as boundary disputes, sharing of river waters, constitutional powers, or financial obligations between governments. However, Article 131 does not cover disputes arising out of treaties or agreements entered into before the Constitution came into force, unless the agreement itself provides otherwise. The original jurisdiction under Article 131 helps the Supreme Court act as a neutral arbiter in federal disputes, thereby maintaining the federal balance and ensuring constitutional harmony between the Union and the states. Writ jurisdiction, Article 32. Under Article 32 of the Constitution, the Supreme Court of India has writ jurisdiction to enforce fundamental rights. It empowers any person whose fundamental rights are violated to approach the Supreme Court directly. Ambedkar described Article 32 as the heart and soul of the Constitution because it provides an effective constitutional remedy. The Supreme Court may issue the following writs. Habeas corpus. Habeas corpus is one of the most important writs issued by the Supreme Court of India under Article 32 for the protection of personal liberty. The term habeas corpus literally means to produce the body. This writ is issued when a person is illegally or unlawfully detained. Through this writ, the court orders the authority or person who has detained someone to produce the detained person before the court and justify the legality of the detention. If the court finds that the detention is illegal, it orders the immediate release of the person. Habeas corpus can be filed by the detained person, or any other person on his/her behalf. This writ acts as a powerful safeguard against arbitrary arrest and detention by the state. It can be issued even during emergencies, except when Article 359 suspends the right. Habeas corpus is a cornerstone of individual freedom and a vital instrument for protecting personal liberty and human rights, making it one of the strongest remedies under the Indian Constitution. Mandamus. Mandamus is a constitutional writ issued by the Supreme Court of India under Article 32, and by High Courts under Article 226, to command a public authority to perform a legal or public duty which it has failed or refused to perform. The word mandamus means we command. This writ is issued against public authorities such as government departments, public officials, statutory bodies, and lower courts tribunals, when acting administratively. It cannot be issued against private individuals or to enforce private contracts. Conditions for issue. There must be a legal right in the petitioner. There must be a public duty imposed on the authority. The authority must have failed to perform that duty. No adequate alternative remedy should be available. Rule of discretion. Limitations. Mandamus is not issued to compel discretionary acts against the President or governors for constitutional duties, or to enforce purely contractual obligations. Mandamus ensures that public authorities act according to law, prevents administrative inaction, and upholds the rule of law by making the state accountable to citizens. Prohibition. Prohibition is a constitutional writ issued by the Supreme Court of India under Article 32, and by High Courts under Article 226, to prevent an inferior court or tribunal from continuing proceedings that are beyond its jurisdiction or in violation of law. The writ of prohibition is preventive in nature. This writ is issued during the pendency of proceedings, i.e., before the inferior court or tribunal has passed a final order. It directs the authority to stop the proceedings immediately when it acts without jurisdiction, in excess of jurisdiction, or contrary to principles of natural justice. Against whom it lies. Judicial or quasi-judicial bodies such as lower courts, tribunals, or authorities performing judicial functions. It does not lie against administrative or legislative authorities. Purpose. The object of prohibition is to keep inferior courts within the limits of their lawful authority and to prevent illegal or unjust proceedings. The writ of prohibition plays a crucial role in judicial control over lower courts and tribunals, ensuring that they act within their jurisdiction and in accordance with law and natural justice, thereby upholding the rule of law. Certiorari. Certiorari is a constitutional writ issued by the Supreme Court of India under Article 32, and by High Courts under Article 226, to quash or set aside an illegal order passed by an inferior court, tribunal, or quasi-judicial authority. The word certiorari means to be informed. This writ is corrective in nature and is usually issued after the lower authority has passed a final order. The Supreme Court may issue certiorari when the authority has acted without jurisdiction or in excess of jurisdiction, committed an error of law apparent on the face of the record, violated the principles of natural justice, such as no hearing, or abused its power. Against whom it lies. Judicial and quasi-judicial bodies, courts, tribunals, statutory authorities. It does not lie against purely administrative actions or legislative acts. The writ of certiorari ensures judicial control over inferior courts and tribunals, corrects legal errors, and protects individuals from illegal or unfair decisions, thereby strengthening the rule of law. Quo warranto. Quo warranto is a constitutional writ issued by the Supreme Court of India under Article 32, and by High Courts under Article 226, to question the legality of a person's claim to a public office. The term quo warranto means by what authority. This writ is issued when a person holds a public office without legal authority, i.e., without fulfilling the statutory or constitutional qualifications prescribed for that office. The court asks the person to show the authority under which the office is held. If the claim is unlawful, the court can remove the person from office. Essential conditions. The office must be a public office created by the Constitution or a statute. The office must be substantive and permanent, not private or contractual. The person must be holding the office without legal authority. Who can file? Unlike other writs, any person can file a petition for quo warranto. Personal injury is not required. Quo warranto acts as a powerful check on illegal appointments, ensures that public offices are held lawfully, and promotes transparency and accountability in public administration. Accountability in public administration. Writ jurisdiction under Article 32 makes the Supreme Court the guardian of fundamental rights, ensuring immediate relief, constitutional supremacy, and the rule of law in India. Appellate jurisdiction. The Supreme Court of India exercises appellate jurisdiction as the final court of appeal in India. This jurisdiction enables the Supreme Court to hear appeals against judgments, decrees, or orders passed by high courts and certain tribunals, ensuring uniform interpretation of law across the country. A. Constitutional appeals, Article 132. An appeal lies to the Supreme Court from a High Court decision if the case involves a substantial question of law as to the interpretation of the Constitution, and the High Court certifies it. B. Civil Appeals, Article 133. Appeals in civil matters lie from the High Court to the Supreme Court subject to conditions prescribed by law, typically involving substantial questions of law of general importance. C. Criminal Appeals, Article 134. Criminal appeals lie to the Supreme Court in specified cases, such as when the High Court has reversed an acquittal and sentenced the accused to death, or when the High Court certifies that the case is fit for appeal. D. Special Leave to Appeal, Article 136. Article 136 confers a discretionary power on the Supreme Court to grant special leave to appeal, SLP, from any judgment or order of any court or tribunal in India, except military courts. This is a wide and flexible power used to prevent miscarriage of justice. Through its appellate jurisdiction, the Supreme Court ensures finality of decisions, uniformity of law, and justice, reinforcing its role as the ultimate judicial authority in India. Advisory Jurisdiction, Article 143. Under Article 143 of the Constitution, the Supreme Court of India exercises advisory jurisdiction, through which the President of India may seek the court's opinion on important questions of law or fact of public importance. This provision enables the President to obtain authoritative legal guidance on complex constitutional or legal issues. The Supreme Court may consider the reference and give its opinion after hearing arguments. However, such an advisory opinion is not binding on the President or the government, though it carries great persuasive and constitutional value. The court may also decline to answer a reference if it considers the question inappropriate. Advisory jurisdiction has been used in significant matters, such as disputes relating to constitutional interpretation, federal relations, and national importance. It helps avoid future conflicts and ensures that executive actions are taken in accordance with constitutional principles. The advisory jurisdiction under Article 143 strengthens constitutional governance by promoting cooperation between the executive and the judiciary, enabling informed decision-making while respecting the independence of the Supreme Court. Review Jurisdiction, Article 137. Under Article 137 of the Constitution, the Supreme Court of India has the power to review its own judgments or orders. This jurisdiction exists to correct errors and prevent miscarriage of justice, while maintaining finality of decisions. A review petition may be filed on limited grounds, such as error apparent on the face of the record, discovery of new and important evidence which could not be produced earlier despite due diligence, or other sufficient reasons analogous to the above. Review jurisdiction is not an appeal in disguise. It is exercised sparingly and only in exceptional cases. The petition is usually considered by the same bench that delivered the original judgment, and it is first examined in chambers, without oral hearing, unless the court directs otherwise. Review jurisdiction under Article 137 balances finality with fairness. It allows the Supreme Court to rectify clear mistakes while preserving judicial certainty, discipline, and the rule of law. Curative jurisdiction. Curative jurisdiction is an extraordinary power evolved by the Supreme Court of India to prevent gross miscarriage of justice, even after a review petition has been dismissed. This jurisdiction was formally recognized in Rupa Ashok Hurra v. Ashok Hurra, 2002. A curative petition can be filed only in exceptional circumstances, such as violation of principles of natural justice, e. a party was not heard, bias of a judge, or other reasons leading to manifest injustice. Procedure and safeguards. The petitioner must certify that the grounds were raised in the review petition. The petition is circulated to a bench of the three seniormost judges and the judges who passed the original judgment, if available. It is usually decided in chambers, without oral hearing, unless the court directs otherwise. Strict scrutiny applies to avoid abuse and to preserve finality. Curative jurisdiction serves as a last resort safety valve in the judicial system. While used sparingly, it reinforces fairness and justice by allowing the Supreme Court to correct exceptional and grave errors without undermining the finality of judgments. Court of Record, Article 129. Under Article 129 of the Constitution, the Supreme Court of India is declared to be a court of record. This means that its judgments, orders, and proceedings are permanently recorded and have evidentiary value, and they cannot be questioned in any other court. Being a court of record also gives the Supreme Court the power to punish for contempt of court. This power enables the court to protect its authority, dignity, and functioning, and to ensure that justice is administered without obstruction. Contempt may be civil, willful disobedience of court orders, or criminal, acts that scandalize the court or obstruct justice. Further, under Article 141, the law declared by the Supreme Court is binding on all courts in India, which reinforces its status as a court of record and ensures uniformity in the application of law. The status of the Supreme Court as a court of record strengthens its supremacy and authority in the judicial system. It ensures respect for judicial decisions, maintains judicial discipline, and upholds the rule of law across the country. Conclusion. The Supreme Court of India possesses the widest and most comprehensive jurisdiction among all courts in India. Through its original, writ, appellate, advisory, review, curative, and court of record jurisdictions, the Supreme Court acts as the final guardian of the Constitution and the ultimate authority of justice. Its jurisdiction ensures effective protection of fundamental rights, maintains the federal balance between the Union and the states, and guarantees uniform interpretation of law throughout the country. Powers such as judicial review, writ jurisdiction under Article 32, and binding precedents under Article 141 strengthen constitutional supremacy and the rule of law. In conclusion, the jurisdiction of the Supreme Court forms the backbone of Indian constitutional democracy, enabling it to uphold justice, liberty, equality, and constitutional governance, and making it an indispensable institution in the Indian legal system.